Welcome to We the People. Writer and activist Arundhati Roy was sentenced to 1 day's imprisonment this past week for contempt of court. The Supreme Court's decision has reopened the public debate on whether freedom of speech and expression has in fact been restricted by the courts in this decision. And of course, it also touches upon the larger question of who will judge the judges. Well, that's what we're going to look at on this episode. And I'd like to start with Prashant Bhushan, who is counsel for Arundhati Roy. Prashant, your position and that of Arundhati, of course, is well known. What I'd like to ask is, where does it go from here? I mean, in some ways, Arundhati finally chose to pay the fine, not spend the next 3 months. Is this in jail? Is this a closed subject now as far as you're concerned? Or is this going to be debated further? Are you people going to think about following up on what you've already done?
No, Arundhati's case is probably a closed chapter, but it has opened a completely new chapter, and it has opened up the whole debate on both the freedom of speech regarding the actions of the judiciary, as well as the accountability of the judiciary itself. Because the whole issue is, does the dignity of the court depend upon what an individual says about the court, or does it depend upon the actions of the court? Does respect and credibility of the court, for example, the Chief Justice of India recently in a public speech said that almost 20% of the judges in this country are corrupt and they are bringing the entire judiciary into disrepute. The question is does the Chief Justice, having said so, lower the dignity of the court or lower the respect for the court, or is it the actions of these corrupt judges which is doing that? After all, the Chief Justice just said something which is commonly perceived.
So you're saying there isn't enough public space for criticism of the court?
That it would be very dangerous to restrict public criticism of the courts by using the power of contempt, because that's today the only kind of accountability that the courts have.
And you of course believe that's what happened in Arundhati's case. Abhishek Singhvi, you wrote an article in a national daily saying Arundhati Roy had sensationalized this whole issue.
I want to make 3 points, Barkha. I don't think it's a case of freedom of speech at all. A case is decided in the context of the facts. Look at this. This is a case about a litigant having fought a case over 2 to 3 years, refusing to accept a judgment. And that's not freedom of expression. That's imputations after you've lost a case on the merits. The Narmada Bachao case was argued for 2 or 3 years. Everybody argued, everybody participated. A 3-judge bench gave a 2-1 dissent judgment. After the judgment, the article, The Greater Common Good, was written in Mr. Mehta's magazine. Thereafter, notice of contempt was issued. 2 of the alleged contemners, including Mr. Prashant Bhushan, said they didn't say what was alleged and attributed to them, and therefore the contempt was dropped. Arundhati, in reply, gave in affidavit a very seriously critical passage, which is reproduced in the judgment. So the issue was post-judgment, a refusal to accept the judgment and criticize it in response to a contempt notice, on which the court, on a second round, issued notice to her, heard her, and then convicted her of contempt, gave her 1 day's token imprisonment. Now, I don't think this is freedom of speech. And 2 other quick points I want to make. If it was freedom of speech also, you have to decide a fundamental question here. Do you have the law of contempt at all or not? The way Prashant just opened, it seems to me that you don't need a law of contempt at all. Good. If that is so, if the Parliamentary Act is repealed, if our founding fathers who put the Constitution in Article 19(2) as a reasonable restriction to free speech and included contempt of court there, if that is repealed, that's fine. But as long as the law stands, I ask myself, how can you ignore a direct attack in an affidavit?
All right, you made your point. Let me get Mr. Venugopal into this now, because Mr. Singhvi makes the point about not accepting a judgment. My point is, looking at it within the framework of political resistance, there is a judgment and there is political opposition, there is opposition from within the citizenry. Do people not have a right to oppose the judgment, oppose the Supreme Court judgment?
Yes, I think they have, but I think the real issue is this. There are 2 conflicting public interests involved. One is the need to maintain the prestige, the dignity, and the independence of the superior courts. Why? Because each one of us, including the press, including the media, including prisoners, they have to go to the court for protection against the state. Now, as against that is a question as to whether in protecting the prestige, the independence of the courts, you can sacrifice, I think, more than freedom of speech, there is another one very important aspect, and that is the liberty of the individual. Because you are being sent to jail. Look at the consequences. Your reputation, your freedom, all that is gone. Secondly comes also the freedom of the press and the freedom of speech. For all these have to be balanced, and I think it is very important that in balancing it, we preserve the dignity, the prestige and the independence of the courts, but the courts will have to now sit back and think, have they gone too far in exercising the powers of contempt? Is it time to sit back and rewrite the rules? Because Arundhati Roy's case clearly, along with 3-4 other earlier cases, would call for a rewriting of the rules governing contempt.
All right, let's get Vinod Mehta. I'll come to the audience in just a bit. Let's get Vinod Mehta in. As Mr. Mehta said when he was introducing himself to this audience, Outlook publishes many of Arundhati's articles. You stood up and spoke in her support on the day the judgment came. Mr. Venugopal makes the point that there is a need to balance. It isn't a simple either or.
You know, I think Arundhati Roy's case throws up one other issue. In 21st century India, all the free institutions of this country, whether it's the press, whether it's the Prime Minister's office, whether it's the presidency, 15-20 years ago you couldn't say anything against the presidency. They are all open to legitimate observation, legitimate criticism and legitimate amount of protest. I think there's a tendency as far as the higher judiciary is concerned, and that's why I think Arundhati Roy's case is so important, to put itself out of the purview and say, listen, we are the higher judiciary, we guard all your rights and freedoms, don't attack us, don't scandalize the authority of the court. And I think in this they go too far. The courts have to be brought back into the purview of legitimate criticism. I think it doesn't undermine the court, it enhances the dignity of the court. What undermines the court is the rather ridiculous comments they made in the Arundhati Roy's case when they said that they would have given her a higher punishment if she was not a woman. Does this befit the Supreme Court of India to make a statement? If you think she is guilty, send her for 3 months.
Well, they obviously thought they were being kind.
But don't pardon her simply because she is a woman, I mean. So I think the courts need to be more relaxed about these matters. We live in the 21st century. In the West, my friends here are more learned about these matters, but this whole contempt of court matter, I understand in the West, I mean, is hardly ever, no judge uses it, it's there on the book, nobody uses it. But in India, this whole idea of scandalizing the authority of the court, what did Arundhati Roy say? What did Mr. Singhvi say? Examine what she said. She made a simple point that there is a disturbing tendency to muzzle criticism. Now, does this, I mean, this is such a banal, we all say, if you said this about the press, or if you said this about the Prime Minister's office or the President, would you put that person into court? I mean, you can say it's a serious charge, but it's made every day, so why shouldn't the courts be? I think they've just been oversensitive and made a fool of themselves.
So they're taking themselves too seriously, according to you, Chandan.
Well, you see, there are some very, very important points have already been made. I would, there's a lot in what Vinod says. I do agree. Supreme Court tends to be very, very prickly on certain things, and they tend to kind of, overreact a lot. But in this particular case, I just suspect that Arundhati wanted it this way. Yes. That there was a certain, deliberation. She is an activist. She has every right. I'm not questioning her right to want it this way. But then, you see, the way she went about it, and as my friend Abhishek just mentioned, that you see there were other contemners. They kind of revised, they said this is not exactly what they said. She could have done it. I mean, you made your point. Having made the point, was there a need to carry on this kind of drama?
What would you have had her do?
I would have had her amend the affidavit. The Supreme Court gave her an opportunity, told her that please amend it. This is not right. I mean, you made your point, now amend it this way so that we can let you off. It virtually went to this extent.
But what do you think she should have amended? What was so disturbing in that she should have taken it back?
I think, you see, there is nothing wrong with legitimate criticism, and I think the law permits that a verdict can be legitimately criticized. You cannot attribute motives to the judiciary.
All right.
And I think this bordered on that, and that's why I believe she should have amended her affidavit and having made the point.
All right, we're going to take a short break, and when we come back, I know Prashant would like to respond to that, but we'll also throw it open to the audience. Political bias. Welcome back to We the People, contempt of court or freedom of speech. That's what we're discussing and debating on this episode. Before I return to our guests, I'm going to take a few questions.
See, I think the thing is getting focused too much just on Arundhati Roy. While it is important what Arundhati Roy has said, I think it is important to look at the context also and the background, which is the Narmada judgment. When judges in the Narmada judgment can make statements about how good or bad dams are, very general statements, then of course people who know about dams and also the general public who are experiencing the submergence from such dams have the right to criticize the judgment. And not only in these cases, but the Supreme Court has started making judgments in many cases which have very wide implications on the lives of millions of people. So obviously the court should be open to public criticism, and I think Arundhati Roy did that, and she was being pinned down because of that.
All right, we'll take one more question before we return to our guests.
My question is that legitimate criticism is allowed, but why name specific judges? Because Arundhati Roy in her affidavit names the Chief Justice of India. So why name specific judges?
Yeah, all right. Those are two very different strands of argument, perhaps both valid questions in their own right. Let's give it to Mr. Venugopal and then go through the others. I'll come to
about this dam. Let me first of all tell you as to what the Supreme Court has been doing. It has been entertaining public interest litigation in regard to pollution, in regard to corruption, in regard to prisoners' rights, in regard to drug abuse, in regard to women, in regard to orphans, children. They have been able to exercise vast powers. And the last case which I was involved in was where every state was required to give food as part of the midday meal scheme, and also in regard to the PDS system. The writ has been running all over the country. Now, how is it that they are able to command the credibility of being able to compel to fall in line? The chief ministers would not listen to the prime minister even in regard to these matters. But when the court says do this, they are prepared to do it. Why? Because so far as the credibility of the court is concerned is very high.
So, but there is a flip argument as well, and which is that as the role of the judiciary expands into public and political space, so must it open itself.
I agree. Therefore, no, I am not disputing that. Therefore, before one decides as to the extent of criticism which the court should be subjected to, let us first of all realize that the court is doing a great public good because of the independence and credibility. The politicians are not able to control it.
It needs to be clarified.
But one minute. But so far as the freedom of speech is concerned, so far as liberty is concerned, it has delivered judgments in the by exercising contempt powers, which I think far exceed what has been happening in other countries.
Precisely. See, the point is that this is the Supreme Court which has actually expanded the space for debate, dialogue, criticism. And this is a different case. Barkha, I don't think it's a simple issue of, contempt of court versus freedom of speech. I mean, freedom of speech is something which the Supreme Court has been very, very strong on. But here, what the point I wanted to make again is that this has hijacked the agenda. This lady just mentioned. It's not just about Arundhati Roy, it's about Narmada Bachao Andolan. But we are not discussing Narmada Bachao Andolan, it's all focused on Arundhati Roy.
Okay. All right, Vinod, you wanted to make a point. I'm coming to you right after that.
You see, I mean, I find it ironical that of course the Supreme Court has widened the space for freedom of speech, but when it comes to them, there seem to be two rules. A, B, this whole idea of Arundhati Roy creating drama. That she writes of course she's not an LIC clerk, she writes an affidavit like a writer. You must examine the substance of the affidavit. Has the Supreme Court sentenced Arundhati Roy because her language is very colourful? Has the Supreme Court sentenced Arundhati Roy because her supporters were protesting and outside the Supreme Court? You have to examine the substance of what she said. And if you look at the affidavit, if you look at she made 2 points. One, she said, was that the Supreme Court couldn't spare a sitting judge for the Tehelka case, but on this matter they are going on and on. The second thing was about dissent. I think they are both serious points, but they don't deserve this symbolic one-day punishment. I think the court makes a mockery of itself when it does this thing, and this is a question about freedom of speech. No, make no mistake. And all of us in the media, Chandan Mitra will confirm, when we sit in our editorial conference and we get a story about the Supreme Court, I mean, we start sweating, you know, we start reading it upwards and downwards, that maybe in paragraph 3, line 4, there may be something with the courts will, and who wants to tangle with the Supreme Court of this country?
And who wants to go to jail even if
and
only one day?
I've been held up for contempt twice.
You have?
I have.
All right, we'll come to that. We'll ask you to tell us that story in just a bit. Prashant, someone raised the point that legitimate criticism is fine, but why name the Chief Justice? Why name judges?
No,
Would you like to respond to that?
Yeah, I think we need to get our facts clear, because I don't think Abhishek and Chandan have their facts right on this. She did not go to court as a litigant. She didn't file that petition. It was the Narmada Bachao Andolan which had filed that petition. She merely wrote an article about that, an interim order made by the Supreme Court called the Greater Common Good. Thereafter, after the final judgment came, there was a protest outside the Supreme Court led by Medha Patkar against the judgment, in which Arundhati Roy participated as an observer. After that, some lawyers filed a contempt petition making wild allegations against Medha Patkar, Arundhati Roy and myself, saying that we had assaulted them, we had threatened to kill them, and we had raised all kinds of wild slogans against the court.
And that petition was thrown out by the Supreme Court.
All three of us filed affidavits in reply pointing out that this is not correct. In addition, both Medha Patkar and Arundhati Roy pointed out that this kind of contempt notice to these kind of persons gives an impression. Arundhati Roy in particular pointed out that when the court is too busy to spare a sitting judge for the Tehelka inquiry, and it entertains such a frivolous and absurd petition which doesn't pass the minimum credibility test and issues notice to 3 persons who have recently criticized the court, then it gives an impression as if the court is trying to silence criticism and muzzle dissent.
All right, let's get Abhishek in briefly before we take another break.
I think it's important to harken back to the fact that I cannot conceive of any legal system where freedom of speech expression, press freedom, is more protected than in India. This includes America. There is no more dynamic constitutional system where free speech and expression is completely, totally, holistically and comprehensively protected. Any of us can ask that question. You look at our press, look at the way our editors write, speak.
No, but
they
the
are free.
point being made is
Number
it's much
two,
easier for the press to be free when it comes to the political system, the political establishment,
yes,
any institution except the judiciary.
Correct.
No, fair criticism of the judgments. We do it every day. As lawyers we do it. In the bar we do it. All of us write about judgments. I'm sure Mr. Mehta uses very strong, colourful language about the judgment.
No, I don't.
I
don't make any. I make colourful languages about everybody, but not about judgment, my friend. I assure you, I make no colourful language about judgment.
To my mind, Mr. Mehta, you've used fairly strong, colourful language in the last 2 minutes about the judges in the court. So that you have witnesses around here to attest to that. But that apart, the point of the matter is we have a very liberal Supreme Court on press freedom, 1. 2. We have a very liberal Supreme Court on contempt of court law. You have any number of cases where people have been let off. In this very case, 2 were let off. Arundhati herself was discharged in the first round. You have several other cases. You had Wa India recently. You had earlier judgments. You had the case of Mohammad Yunus, who said that a judge who allows people to sit when the national anthem is singing is neither Indian nor a judge. And Justice Chinnappa Reddy was involved, and he was discharged. There are for every case of Shiv Shankar, which I have personally written, is wrong. But then 2 wrongs don't make a right. I think that was playing close to the line. The fact that in that judgment they let off a person doesn't mean that in another case you can have a swipe at the Supreme Court again.
Point taken. I'm going to have to cut you short there. It's time for a break. We'll come back in just a minute. Welcome back. Let's take a couple of more questions before going back to our guests. Go ahead. Here, you can hold the mic.
We forget a point that it is the judges who have to decide whether in a particular case contempt has been committed or not committed. So once they decide that contempt has been committed, why should there be any criticism or discussion?
Why not?
Because it is their work. If everybody starts doing, if everybody starts justifying or defending his action, then someday a murderer will come. He says, I do it. Kalyan Singh did it for publicity. Arundhati has done it only for publicity. If she was so sincere, she would have gone to jail for 3 months. She wouldn't have paid the fine.
Okay, all right, you made your point. Let's get another question in.
I think the question is not whether the Supreme Court is too touchy or not. It is not touchy about Ashok Singhal when the VHP repeatedly violates Supreme Court orders without any kind of warning or rebuke, not even a rebuke. So the question is about whether there is a difference between dissent and contempt. And I feel that in a democracy, there has to be the right to dissent. And what lowers the legitimacy and dignity of the court is not Arundhati's comment or anyone's criticism, but in fact the court lowers its own dignity when it tries to muzzle dissent.
All right, that's an interesting point you've raised here, and I'd like to ask Mr. Venugopal this question. Many people, one has just been speaking to, say you have an organization in this country which had been saying up till this point, because they've changed their stand now, we will not abide by the court verdict on Ayodhya. They openly, publicly used to say it at every press conference. Now there's negotiations on. Would that qualify as contempt in your view?
See, I don't think the mere saying that we will not, taking a political stance or a religious stance, will amount to contempt. But the day they break the order which the court has passed and violate it, then it is contempt and it becomes contempt. But I'd like to...
Let him finish. Were you finishing your point, sir?
Yes, I would like to make a point here that has anybody realized what is the basis on which this contempt action is being taken? It's based on a vague word known as scandalizing the court. And so far as the English courts are concerned, a long time back they said, we are no more going to take action for scandalizing the court. If you commit a criminal offense, you know in advance what is the offense, what are the ingredients. Unfortunately, so far as scandalizing the court is concerned, nobody knows what the content is. Lawyers, laymen, least of all.
So it's open to the discretion of the particular judge.
That I think is a great drawback so far as this power is concerned.
Chandan, you said you were hauled up for contempt as a journalist. You want to just briefly run us through what happened?
Yes, I mean I was hauled up on 2 occasions for articles, one written by me and another which I as editor happened to publish. And that's in the context in which I said Supreme Court is often a little too prickly and touchy about these things. But then you see, I do feel, yes, on both occasions we had fairly prolonged arguments. Mr. Ram Jethmalani was my lawyer in one case, and there was a very prolonged argument on what the contempt and what scandalizing the court really means, lowering the dignity of the judiciary, these kind of phrases. But then you see, I am totally with Abhishek when he says that as long as the law stands on the statute books, it must be respected. And the judges are the people to whom this country has vested the authority to make this judgment. So if in a particular case they rightly or wrongly conclude something, while you are free to criticize, I think the line must be drawn between fair and legitimate criticism and defiance. And the VHP example was actually very good. I think the VHP does defy. The law of the land must come down on them like a ton of bricks. And the kind of things that are now being said only give handle to organizations like the VHP. So it's not a good precedent that's being set.
Okay, Vinod, let me ask you a question. Prashant, in just 2 minutes I'll come to you. Let me ask you a question. If one of your reporters uncovered a story on a particular judge in the Supreme Court and had evidence of corruption against that judge, I'm asking a generic question. I should qualify because then I may be hauled up for contempt. Would you publish that article, or would you think?
I would be very scared. I would think about it a great deal. I would weigh I would need really a smoking gun in the case of a judge as opposed to any other public figure. But can I just make one other point? That what is happening in this discussion is that the personality of Arundhati Roy is becoming as big an issue as the contempt issue. And I think because people either love Arundhati Roy or hate Arundhati Roy, and I know this because I received lots of mail on that. I received lots of mail on that subject. I think this whole thing is, and what we are really asking for, and I'm praying to the judges of the Supreme Court, is to be a little more relaxed. I mean, look at the phrase, scandalizing the authority. I mean, this would be Charles Dickens? Well, what are we talking about? We're living in the 21st century. We're using such archaic language. You are doing a great job in the Supreme Court. You're protecting our freedoms. For God's sake, be a little more relaxed. Your authority is actually scandalized when you do something like that.
All right, I know both Abhishek and Prashant have points to make. Just one more question this side and then I'll come here. Just get a hold of the mic.
Taking off from Vinod Mehta's point and a lot of other things, what people seem to forget is that the contempt hearing is actually got a history of about 2 or 3 years. Immediately after the Greater Common Good, which incidentally came out much before the judgment, contrary to what you said, sir. S.P. Bharucha, who's now the Chief Justice, came out, there were already contempt proceedings initiated, said, I am not inclined to take action in contempt against Medha Patkar, Shripad Dharmadhikari and Arundhati Roy because the court's shoulders are broad enough to shrug off their comments and because the issue should not shift from resettlement and rehabilitation. Now, despite the MCP nature of the comment, it has shifted. The court has shifted its stance very radically in the past 2 years and has been extremely prickly, as everybody has pointed out.
Okay.
So what this is coming to is the fact that suddenly, over the past 2 years, the space for freedom of expression is going. And
okay, you've made your point. I think that you've made your point. We get Mr. Singhvi and then Prashant.
On a point of information, the immediately preceding para to what you've read, Justice Bharucha, the same order, said he found the remarks, he disapproved of the remarks, he found them offensive, but decided not to take action. So that's right. So therefore, he didn't approve the remarks. But I want to go back to Vinod's point, which is very important. I think that example of if you find credible information of corruption, what happens when an editor publishes it? He said he would be, or does not. He said he would be hesitant or he would think twice, or he says he would perhaps sweat. It happened very recently. N. Ram's Frontline published several pieces with great graphic detail involving allegations about a former Chief Justice who's now retired. Nobody thought of issuing contempt notice. Similar allegations were thrown about, bandied about in a very swashbuckling manner by one Vineet Narayan. It was allowed the first time. A second time a contempt notice was issued. Why? All of us reasonable sounding people here can judge the difference between N. Ram's Frontline article detailing allegations of corruption in graphic detail, and Mr. Prashant Bhushan knows that well, versus Vineet Narayan's Kal Chakra rag sheet example. And I think one deserves contempt action, the other doesn't. And the other thing I want to point out here is that I agree entirely. The Supreme Court needs to be more consistent. Consistency has not been a virtue of the Supreme Court over the years, and you have the aberrations. You have the aberration of the P. Shiv Shankar case, which gives certain food for thought about how. But that cannot mean two wrongs don't make a right. That was very close to the line, and although a detailed explanation is given in that judgment, but it could have qualified for contempt, and I believe it should have qualified for contempt.
Okay, Prashant,
it's not a question of two wrongs making a right, etc. The question is, it is the judges themselves who exercise this contempt power. What Chandan and Abhishek have been saying, so long as the contempt law stands as it is, it's all right. The question is it all right? Is it all right for the judges to sit in judgment in their own cause? Because clearly this is a matter between the court and the citizen. And the court in this matter sits as a judge in its own cause, and that's why, as Vinod said,
who should?
Nobody knows.
Then why would you amend that?
There is a basic principle.
Don't speak out of turn in the audience, please.
There is a basic principle of natural justice which says that a judge should not be a judge in his own cause. Therefore, this power can be vested with some other authority. Yeah. And it should be vested. If this power is required at all, it should be vested.
Okay, we go to
just one other thing.
Yeah, briefly.
In the judgment they have said, regarding Shiv Shankar's judgment, they say that Shiv Shankar could make those comments that the Supreme Court has become a haven for antisocial elements, bright burners and a whole horde of reactionaries, because Shiv Shankar was an insider, having been a judge and having been the law minister. Therefore he could say that, and that was permissible. But a common citizen cannot make any comments on the conduct of the judiciary. This is what this judgment says.
All right, you've made your point. We're going to take a break, and after the break, the question that you've raised, you make the point that it's all very in-house, sort of this clubby thing of judges judging themselves. Who should judge the judges? That's after the break.
Is claiming to speak for the common man
and claiming to support the common man in this judgment continuously. The common man actually judges the Supreme Court on the basis of its judgments, which have been consistently anti-people, against their people's right to livelihood, people's right to food.
That's a very generalized statement. I mean, can you give a specific example? Because I think most of us agree that it hasn't quite been that way, that the judiciary is the one institution that people do actually turn to, having been disillusioned with every other institution.
There are numerous judgments.
Give us one example.
The Shankar Gohanyogi case, and in the factory, the displacement of the removal of workers, in the Supreme Court judgment in the Enron case, there actually have been numerous cases, and I could list you an entire
okay, so you're making the point.
The other point I want to make is that contempt is also constituted by non-implementation of judgments of the Supreme Court itself. And when you come to, for instance, Supreme Court has not even implemented the Vishaka judgment on sexual harassment at the workplace, which came out in '97, in its own precinct. So if the Supreme Court cannot implement its own judgments in its own precinct and does not choose to take suo moto notice of that contempt, how do you look upon
Your last point raises an interesting point. I know that an NGO conducted an anonymous survey of judges of the Supreme Court and the High Court on attitudes to women, and some of those results, the judges listening to this will pardon me, were really quite shocking. Mr. Venugopal, that's an important question. A sexual harassment code that all organizations are supposed to have, the Supreme Court doesn't have it in its own precincts. That raises a question. Who can speak out against the judges?
You see, we are really going back to this question. Nobody has said that fair criticism is not permitted, but who knows what is fair criticism and what is not fair criticism? The lines have not been drawn. That is a real problem so far as this particular offense of criminal contempt. This is criminal contempt. Therefore, I believe that it is time that the rules were rewritten. One, today people are doubtful as to whether, in regard to this example given of alleging corruption against a particular judge with material and evidence, whether truth is a defense or not. Matter has now been referred to a constitution bench for its final decision.
I'm sorry to interrupt you, but the lady here had a question exactly on that.
That's exactly what I wanted to say.
Yes.
Truth is not a defense against contempt of court.
You think it's not?
It's not.
Why is that?
Like he just said, if you have proof, you have everything to say that the judge is not straight.
It is not just contempt of court on libel. On libel matter itself, truth is not a defense.
Not only libel, but even otherwise. I mean, if I had all the information that he's a chore, I can't say he's a chore. They'd hold me in contempt. Whereas if I was a chore, they'd put me straight into jail.
You believe the truth should be a defense?
Should be something to hold against. You should not be held in contempt of court. If I know that it's true and I can prove it's true, then I should not be held in contempt, even if it's against the judge.
Okay.
This is what I say.
All right. Would any one of you who'd like to respond to that? Maybe Mr. Singhvi. Go ahead.
I think we have to keep the normative and the positive aspect separate, what the law ought to be and what it is. I agree entirely that truth should be a defense. There are some judgments in the 70s which have created a doubt whether it is a defense or not, and the matter now stands referred to the Constitution bench. It is strongly likely that the Constitution bench decides the matter will hold truth to be a defense, and in fact that holding would remove many of the allegations of inconsistency and problems in the contempt law. But there also there's a caveat. You have to be careful. First of all, truth will arise only in a few small cases of contempt where objective statement of fact are asserted, because it's only there that you will say this is true or untrue. For a statement like Arundhati Roy's, you cannot say that she can plead defense of truth at all. She said they are harassing, they harass and they...
So where there are possibly two opinions or more...
There you have to only take care of one thing, and that's going to be in the legislative scheme or in the constitutional judgment as to how you prevent a frivolous defense of truth being raised. Anybody says anything they like and they say, I'll plead truth. And the process of pleading truth actually leads to more contempt than the original contempt.
All right, we're closing in on this program, so let's come back to a focused thing.
I think some very, very important issues have been raised. There is no doubt that the contempt law as it stands needs to be seriously examined and perhaps amended. See, because this whole thing, I think it's absolutely hilarious, because in one of my cases there was a huge argument as to if truth is not a defense, how can belief in truth be a defense? See, now, I mean, you're really splitting hair and discussing metaphysics which has no relevance to contemporary reality. By all means, let us go ahead and change the law. But even if you change the law, Arundhati's case will still amount to contempt. So I think we need to be absolutely clear.
All right, I'm going to have to take another break. And like I said, we didn't actually touch upon in this segment what we'd embarked on to discuss, which is who should judge the judges. That's after the break then.
Why not the judges? Who are they accountable to? When they pass on a judgment, I mean, they can just hold anybody liable for contempt of court. I mean, as a layman here, I would be scared. Like, I would agree with Mr. Mehta here.
Okay, that's an important point.
See, this thing about who is going to judge the judges, fair criticism. Now, who decides that this is fair criticism of the judge? The judge himself decides it's fair criticism or not. So you get into very subjective areas. You get, for example, the media. If there's an aggrieved party in the media and they feel, I say it's fair criticism, but the aggrieved party feels it's unfair criticism, he goes to the press council. There are libel laws in the country. But where do you go as far as the higher judiciary is concerned? So I think we need to, there are not enough fora where aggrieved people can go. And why is it considered a great impertinence to protest against a judgment of the Supreme Court? This is a free country. Narmada Bachao judgment has been passed, what, 3-2? So the people who are aggrieved want to parade outside the Supreme Court. This is a free, as long as they don't break the law and order, they have every right to do so. Simply, Arundhati Roy, can I just come back to Arundhati Roy? She accepted the verdict. She went inside prison. She didn't challenge the verdict of the court. She came out and she made a statement. She was inside, but she didn't challenge the authority of the Supreme Court. So, but who is going to judge the judges? The judges are going to judge themselves. Then we are in a very difficult situation.
Okay, one more question, then we'll throw open that question to the panelists. Go ahead.
Democracy, actually, all institutions derive power from the people. Now, the power of the court to punish for contempt has been given to courts to do justice to people. It has not been given that if a judge feels that criticism is unfair or unreasonable. That is not why this power has been given. And like any other citizen, the judge can very well, which is the law in the West, can go and file like any other citizen for defamation, libel. There is nothing. This power is to be used to do justice to people.
All right.
Now what happens? Like there is one, that Chief Judicial Magistrate of Nadiad, if you remember, was paraded by the police. And the Supreme Court punished those people for contempt of court. Now what message is given? There are hundreds of cases of police harassing innocent citizens, but the Supreme Court does not think it fit to exercise their power to punish them. Only when it comes to the judiciary does it exercise it.
Okay, there is a larger question that the lady there asked Mr. Venugopal, who are the judges accountable to? Prashant Bhushan made the point earlier that there should be actually a body outside of the judiciary that judges the judges. Yeah, I'll come back to you.
No, about this
I will come back to you. Let Mr. Venugopal respond to what I've just said.
So what has to be remembered is that there are 600 judges of the high courts who have all been exercising the same power of contempt. Every judgment of theirs is appealable as of right to the Supreme Court. Then comes the question, what about the Supreme Court? The Supreme Court certainly is liable to be criticized for its judgments. And you can criticize it in the strongest terms possible. There is no contempt involved. It's only when you attack the judge that is not permissible, because you will be undermining their authority. You will be attacking their credibility. That is all that is not permissible.
But the question that the judges shouldn't judge themselves. There should be somebody outside, a neutral body.
No, I think the 1971 Act has provided for it. Suppose a contempt is committed in the face of the court, that man can say, don't try this case yourself, please transfer it to some other bench. Suppose you do something which the court believes is against its dignity, then you are entitled to ask for the case to be taken up by some other bench.
So you're saying the present system is all right on that?
I think so.
But it's still it is still a very in-house clubby thing. You are still within the courts. Like in the media, there is a press council, which is an independent body. So if you are aggrieved against
there is
a body. There exists a body. All I'm saying that it's a very good idea that there should be a body outside the courts. which should be made up of eminent people. I think this is certainly worth a thought. It's a much better thing than to have everything in a very incestuous way inside. One judge judges the other, says, please excuse me from this case. This is a very clubby.
Chandan, and then I'll go that side.
You know, I think, again, we should not get swayed by this one individual case and come up with ideas which will completely negate the entire democratic structure that we have given this country and we are so proud of. You see, this is a globally accepted system. We are not a different species of human beings. Even whether it's in the US or in Britain, wherever you have this kind of a judicial system, this has to be ultimately, if there is contempt is committed, the Supreme Court is the final authority, and talk about going outside to another system. I mean, on what basis will this outside body function?
All right,
we
have to take another break. I know our two panelists this side haven't spoken. They get the last word in the last segment after the break.
Political biases that are operating, and if these biases are exposed, then if pointing it out is associating motives to it, and if it is amounting to scandalizing authority, then it is problematic. In the Bhavri Devi case, the judge made a comment about how untouchable woman cannot be raped by upper caste men. This is a ridiculous statement, and if this is not protested, if this was not protested by women's groups, then it would have passed off.
And so these two statements, I think, shows us how complex the whole thing is. Let me get Mr. Singhvi and Mr. Bhushan here. Mr. Singhvi, one point is that the current code of conduct doesn't actually allow a judge to go and say file a defamation suit or libel or speak up. The other point is that judges are also human beings, and like all of us, they represent a set of prejudices and perhaps even, as politicians do, sometimes corruption. How do we question that?
Thank God you don't permit judges to go and file defamation suits. I'm very disturbed at the suggestion to destroy the very fabric of a system of which you are proud. You must remember one basic thing here. There is, when we say judge, we forget the hierarchy of courts. There's a hierarchy of courts, there's the doctrine of finality. The Supreme Court is right because it is final. It is not final because it is right. I dare say that if there was a Supreme Court above the Supreme Court, 50% of judgment would be reversed. We're all fallible. But the point of the matter is, there is a lower court, a trial court, there is a district court, there is a high court. Within the high court, there is a division bench appeal intra-high court, and then there is a Supreme Court. So there is an inbuilt correction mechanism provided.
What if the Supreme Court is not right? What if the Supreme Court is just not right?
The law of the land says, public policy says that there has to be a quietus sometime. That's the doctrine of finality. There is no end to it. If the Supreme Court is not right, the first appellate court which you create above the Supreme Court will reverse it in 25% cases. But then there will be a court above that and a court above that. So the man's concept of public policy says you have to end things somewhere. And that's a very important component of administration of justice.
And Prashant, obviously you don't agree, so.
You have to end things. The fact that you have to end things somewhere doesn't mean that the judgment cannot be criticized. The point is, everybody in this country recognizes, even the Chief Justice recently lamented the fact that the higher judiciary has just no accountability and that nothing can be done to corrupt judges because the system of impeachment has been found to be unworkable. Now, if in this situation you even prevent people from commenting upon or criticizing the courts, then that will lead to a very dangerous situation of judicial tyranny. What is the flip side? Flip side is that, well, suppose some judge is defamed. It's being suggested that he can't file a defamation suit or he can't
speak up for him or herself.
Why not? The point, there is the law of defamation and libel is available to every citizen. And in fact, for a judge, he does not even have to personally go and file a criminal complaint. He just has to write a letter to the superintendent of police, and under the code of criminal procedure, the superintendent of police takes up the case on his behalf.
All right, those are two very...
This works on a certain dignity, a certain prestige of the court system. If you start having judges as litigants in defamation matters, I think that's the beginning of the end of the entire system.
Okay,
I can't conceive of anything like
that.
that.
That's a very elitist view.
That's an elitist view, says Prashant Bhushan. We're closing in on this program. Chandan and Vinod and Mr. Venugopal, just brief final comments from all three of you.
No, you see, I think there is one problem which needs to be tackled. I find a certain self-righteousness coming in every time there are judgments that people don't like. Now, there will be judgments you don't like. There are so many cases where, yes, I mean, you may entirely agree that the judgment was unfair, incorrect, whatever. But, to kind of question the motives, question this and attribute it to biases, prejudices all the time when you lose. When you win, it's all right. The majesty of the Supreme Court is great. I think we should be a little more honest in these matters.
All right, Vinod.
In the 21st century, when India is opening up, when all its democratic institutions are opening up, I think the Supreme Court does itself a great deal of injustice by putting itself outside the purview of criticism. We can argue about what level of criticism, we can argue about how much criticism, but the Supreme Court cannot be the last holy cow in India.
All right, the last word here, Mr. Venugopal.
I personally feel that a much greater restraint has to be exercised by the Supreme Court of India and by the High Courts in exercise of its power of contempt. We are seeing now a reaction throughout the country for the last about 3-4 years. Secondly, I think it is quite wrong on the part of judges to summon an alleged contemnor before you find that he is guilty of contempt, make him stand there in court day after day for a number of hearings even before he is found guilty, including chief secretaries to government and so on.
All right, as Mr. Singhvi said, it has to stop somewhere. This program has to end right here. Thank you very much. This is final. So we're going to have to close right here. Thank you, everybody.